At this moment, a firearm stored inside your own residence could already place you in violation of the law without your knowledge. During the past month, 7 gun owners were taken into custody for breaking storage regulations they had never heard about. This report examines 7 major firearm storage violations that can result in arrest, even inside your own home. By the end, you will understand the legal requirements for firearm storage in different circumstances, including situations where regulations appear difficult to navigate. A recent development has raised concern among many firearm owners. Michigan initiated its first criminal prosecutions under newly enacted safe storage requirements during 2024. In California, 3 parents faced prosecution last year for negligent firearm storage. 2 received felony convictions and permanently lost their firearm rights. Potential penalties include fines reaching $10,000 and prison sentences extending to 5 years. These individuals were not career criminals. They were lawful firearm owners who believed they were following the rules correctly. One of the most common issues involves loaded firearms that can be reached by children. Consider a situation where a loaded handgun intended for home defense is kept in a nightstand drawer. A 12-year-old child knows where it is stored. The owner believes firearm safety training is sufficient protection. Under child access prevention statutes now enforced in 27 states, including California, Florida, Texas, Illinois, and New York, that assumption can create serious legal problems. If a minor is able to gain access to a loaded firearm without authorization, a violation may already exist. It does not matter whether the child ever handles the weapon. It does not matter whether an incident occurs. In California, when no injury takes place, the offense may be prosecuted as a misdemeanor, carrying up to 1 year in county jail, along with a $1,000 fine. If the child later uses the firearm and someone is injured or killed, felony prosecution becomes possible. Michigan's 2024 Safe Storage Statute imposes penalties of up to 5 years in prison and a $5,000 fine when improper storage contributes to an injury. The offense is classified as a Class E felony and can permanently eliminate firearm ownership rights. To remain compliant, a quick-access biometric safe is one option for a home defense firearm. These devices can open in less than 2 seconds using fingerprint identification while also providing secure storage. If purchasing a safe is not immediately possible, a cable lock can be installed through the firearms action while ammunition is stored separately in a locked container. Maintaining photographs and purchase receipts documenting the storage method can also help establish proof of compliance if questions arise later. It is equally important to review the exact requirements of the state involved because definitions differ. In California, a locked container must be completely enclosed and secured with a lock. Illinois requires placement inside a securely locked box. The situation becomes even more complicated because storage requirements may still apply when no children live in the home. Another frequently misunderstood issue involves mandatory locking devices required by certain states. Many people assume that living alone removes storage obligations. That assumption can be incorrect. Massachusetts, New York, Connecticut, and New Jersey require firearms not actively being used to be secured with trigger locks or stored inside locked containers, regardless of whether children are present. As an example, leaving an AR-15 standing unsecured in a closet can constitute a criminal offense even if it remains inside a private bedroom. If law enforcement enters the residence for any reason, including a wellness check, a domestic disturbance response, or even a noise complaint, and discovers an unsecured firearm, charges may follow. Massachusetts treats violations of safe storage requirements as a felony punishable by up to 2.5 years in prison and a $10,000 fine. Firearms may be seized immediately, and the license to carry can be permanently revoked. In New York, the offense may be prosecuted as a Class A misdemeanor carrying up to 1 year of incarceration. A single unsecured firearm can be enough to trigger enforcement. For compliance, residents of Massachusetts, New York, Connecticut, and New Jersey should ensure every firearm has either a trigger lock or a cable lock whenever it is not being carried or actively controlled. A gun safe or locking cabinet can provide another compliant storage option. For long guns, wall-mounted racks equipped with key-operated locks generally satisfy legal requirements in many jurisdictions. A carry pistol should either remain on the owner's person or be placed inside a quick-access safe. In practical terms, in use means the firearm is physically carried or remains under immediate control. When visitors, contractors, or guests enter the home, firearms should be secured beforehand. Temporary access by others may create legal issues even in locations without the strictest storage statutes. Keeping records and documentation remains important throughout the process. Some firearm owners believe a vehicle offers safer legal protection than a residence. Transportation laws show otherwise. A common scenario begins after a trip to the shooting range. An unloaded pistol is placed inside the center console while a magazine is stored in the glove compartment. The owner believes separating the firearm from the ammunition satisfies legal requirements. A traffic stop occurs because of a broken taillight. In 11 states, the driver must inform the officer that a firearm is present inside the vehicle. When the officer asks where the firearm is located, the driver points toward the center console. The situation quickly escalates. States such as Ohio, Pennsylvania, and Michigan may classify transport as improper when a firearm or ammunition remains accessible from the passenger compartment without the required concealed carry authorization, even when the firearm and ammunition are stored separately. In Ohio, improper transportation of a firearm can result in a fourth-degree felony carrying penalties of up to 18 months in prison and a $5,000 fine. Michigan allows prosecution carrying up to 5 years in prison along with permanent loss of firearm rights. Possession of a concealed carry permit does not automatically resolve every transportation issue. If storage and transport requirements are not followed during travel, the permit may not shield the owner from arrest. Officers may still have authority to make an immediate arrest based on the circumstances encountered during the stop. If you do not possess a concealed carry permit, the firearm must remain unloaded, enclosed in a case, and placed inside a trunk or another locked compartment that cannot be accessed from the passenger section of the vehicle. A hard-sided locked gun case stored in the trunk satisfies that requirement. A firearm placed on the back seat or beneath a seat does not. Ammunition should be secured separately inside a different locked container. For travel crossing state lines, compliance with the Firearm Owners Protection Act is essential. Firearms should remain unloaded, enclosed in a case, and locked inside the trunk throughout interstate transportation. Those who hold concealed carry permits should verify permit reciprocity before entering each state. 15 states do not recognize permits issued elsewhere. In addition, transportation violations can still result in enforcement regardless of permit status. During a traffic stop, hands should remain visible at all times. Notify the officer immediately about the firearm and follow every instruction provided. Never attempt to reach toward the weapon or its storage case unless specifically authorized. The next issue involves firearm storage in locations that many owners assume are unrestricted, simply because they are on private property. Many homeowners believe firearm storage is permitted anywhere they own. That belief can create serious legal exposure. Federal law may apply if a residence is located within 1,000 foot of a school zone. This can include private schools, daycare facilities, and in some states, even homeschool cooperatives. Without a state-issued carry license, possessing firearms within that area may be prohibited unless the firearm is unloaded and secured. As a result, firearms stored in a detached garage, a backyard shed, or even a vehicle parked in the driveway can become a legal issue if any portion of the property falls inside that 1,000-foot boundary. Many firearm owners are unaware that the Gun-Free School Zones Act exists until federal agents or local authorities arrive with a warrant. A violation of the Gun-Free School Zones Act is classified as a federal felony. Penalties can reach 5 years in federal prison along with a $5,000 fine. Firearms may be confiscated, carry permits can be revoked, Second Amendment rights may be permanently lost. During 2023, a firearm owner in Texas faced prosecution after storing rifles in a garage located 800 foot from an elementary school. The result was devastating. He lost everything. To avoid similar problems, property owners can determine the distance to the nearest school using Google Maps. If the property lies within 1,000 foot, a valid state carry license becomes necessary for firearm storage on that property, including inside the home. All firearms within that zone should remain unloaded and secured in locked containers. Those without a carry permit who reside inside the restricted area may choose to store firearms at a trusted friend's residence or inside a gun range locker located beyond the 1,000-foot boundary. Photographs and GPS-based measurements can be retained as proof of compliance. Another issue affects firearm owners who believe they are already following every requirement correctly. Storage of so-called assault weapons without required registration or compliance features has become a major enforcement area. Residents of California, New York, Connecticut, Massachusetts, New Jersey, Maryland, and Hawaii may legally possess an AR-15 or a similar semi-automatic rifle, only if all applicable compliance requirements are met. In California, regulations require registration, fixed magazines, and specific grip arrangements. New York's SAFE Act requires registration and bans certain features, including pistol grips and telescoping stocks. Someone who inherited a rifle, purchased one before a ban, or relocated from a less restrictive state may unknowingly commit a felony by keeping the firearm in its original configuration without completing registration requirements. Law enforcement does not need to observe the firearm being used. Possession alone inside the residence may be sufficient for arrest. In California, possession of an unregistered assault weapon can result in a felony conviction carrying up to 3 years in state prison. Under New York's SAFE Act, the offense is classified as a Class D felony, with penalties reaching 7 years in prison and a $5,000 fine. Connecticut prosecuted 11 firearm owners during 2023 because they failed to register AR-15 rifles after the registration deadline expired. Every one of them lost both their firearms and their firearm ownership rights. The state did not exempt them. prosecution still occurred. Owners of semi-automatic rifles equipped with detachable magazines and prohibited features such as pistol grips, flash suppressors, telescoping stocks, or grenade launcher mounts should immediately verify state registration requirements. In California, registration is completed through the California Department of Justice online portal before the next applicable deadline. In New York, registration is handled through the state police. If registration opportunities have closed, 3 legal paths remain available. The rifle can be modified to eliminate prohibited characteristics through the use of a fixed magazine or featureless grip configuration. It can be surrendered to law enforcement without penalty. It can also be sold outside the state to a dealer located in a state where such firearms remain lawful. Owners should never assume grandfather protection applies automatically. Possession is the offense. Registration serves as the legal safeguard. Photographs, receipts, and registration records should be retained carefully. If authorities ever conduct a raid, those documents may become critical. An even more troubling situation involves firearm owners who comply with storage laws yet still face arrest. The next issue concerns firearms stored in locations where prohibited individuals within the household may gain access. Consider a situation involving an adult son living in the home. 10 years earlier, he was convicted on a felony drug offense. He completed his sentence and has remained clean. The firearms are secured inside a safe located in a bedroom. He does not know the combination. You may believe your firearms are fully protected inside a locked safe. The law may see the situation differently. Under federal statute 18 U.S.C. 922, individuals classified as prohibited persons cannot legally possess firearms or have access to them. Federal prosecutors often apply a broad interpretation of the word access. If your son knows where the safe is located, understands that firearms are stored inside, and could theoretically reach them while you are away, authorities may argue that both of you are violating federal law. This situation extends beyond felony convictions. It can also involve individuals subject to domestic violence, misdemeanor convictions, restraining orders, or dishonorable military discharges. When a prohibited person residing in the household is determined to have access to firearms, the firearm owner may face federal prosecution for aiding and abetting unlawful possession. The penalty can reach 10 years in federal prison, along with a $250,000 fine. The prohibited individual faces the same potential 10-year sentence. During 2022, an Illinois resident received a 5-year federal prison sentence because his brother, a convicted felon living in the same residence, knew where the firearm safe was located. The brother never handled the firearms. That fact did not change the outcome. Both individuals were sent to prison. To reduce risk, every person living in the residence should be evaluated to determine whether they are legally permitted to possess firearms. A background check may be appropriate when uncertainty exists. The cost can be approximately $30. If a prohibited individual lives in the home, firearms should be secured in a place that remains completely inaccessible to that person under all circumstances. A biometric safe, accessible only by the firearm owner, is one option. Another possibility is storing firearms away from the residence, such as in a range locker or at the home of a trusted friend. The location of the safe and any access codes should never be disclosed to others within the household. Security cameras installed in the storage area may provide documentation showing that prohibited individuals never entered the room where firearms were kept. Consulting a firearms attorney to prepare a written agreement documenting that the prohibited person lacks both access and knowledge of firearm locations can create a record demonstrating reasonable preventive measures. When practical, relocation of the prohibited individual may eliminate ongoing legal concerns. Living together with a prohibited person can create continuing exposure that even secure storage may not completely remove. The final issue is one of the most frequently prosecuted firearm storage violations in the United States. It involves failing to report stolen firearms within the reporting deadline required by state law. Imagine returning from a vacation and discovering that a gun safe has been forced open. 3 handguns are gone. The immediate reaction is shock. An insurance company is contacted first. Documentation for a claim begins. Days pass. 2 weeks later, the theft is finally reported to law enforcement. At that point, a separate violation may already have occurred. 11 states, including California, Connecticut, Maryland, Massachusetts, Michigan, New Jersey, New York, Rhode Island, Illinois, Pennsylvania, and Washington, D.C., require firearm thefts to be reported within a period ranging from 24 hours to 72 hours. Missing the deadline by even a single day can result in misdemeanor or felony charges depending on the jurisdiction. Many firearm owners remain unaware of these reporting requirements until criminal charges are filed. In New Jersey, failure to report a stolen firearm within 36 hours is classified as a third-degree felony carrying penalties of up to 5 years in prison and a $15,000 fine. California treats failure to report as a misdemeanor, punishable by as much as 6 months in jail and a $1,000 fine for each firearm not reported. Maryland requires reporting within 72 hours. Failure to comply is a misdemeanor carrying up to 90 days in jail. These cases are often straightforward for prosecutors because the timeline is easy to establish. The timestamp attached to the police report may provide all the evidence necessary. Every firearm owner should know the reporting deadline that applies in their state. California allows 5 days. New Jersey requires reporting within 36 hours. Maryland allows 72 hours. Illinois allows 72 hours. New York requires notification within 24 hours. When a theft is discovered, law enforcement should be contacted immediately before insurance companies, social media posts, or any other actions. Photographs, serial numbers, and a complete inventory of missing firearms should be assembled as quickly as possible. Maintaining a master record containing serial numbers and firearm details in a separate, secure location can make that process much easier. A copy of the police report should be obtained and retained permanently. That document establishes compliance with the reporting deadline. A theft report should also be submitted to the ATF through its website within 48 hours. If a stolen firearm is later used during a crime and the theft was never reported, additional civil liability may arise alongside any criminal consequences. Immediate reporting is essential every time. These are the 7 firearm storage violations discussed throughout this report. Accessible firearms when children are present can result in penalties reaching 5 years in prison in Michigan. Failure to use state-required locking devices can bring a sentence of up to 2.5 years and a $10,000 fine in Massachusetts. Improper vehicle storage during a traffic stop can lead to a 4th-degree felony carrying 18 months in Ohio. Storage inside gun-free zones located on private property can result in 5 years in federal prison under the Gun-Free School Zones Act. Possession of unregistered assault weapons can bring penalties of up to 7 years in New York under the SAFE Act. Allowing access by prohibited persons inside the household can expose a firearm owner to 10 years in federal prison for aiding unlawful possession. Failing to report stolen firearms within required deadlines can lead to 5 years in New Jersey for missing the 36-hour reporting window. Any one of these violations can result in enormous legal expenses, years of lost freedom, or permanent loss of firearm ownership rights. Before ending, take time to review the laws that apply where you live, verify your storage practices, and ensure every requirement is being followed. Staying informed today may prevent serious consequences tomorrow.